I'll read the delinquency statute and the U.S. cases for today. And the mass cases for Thursday. Student searches for next Tuesday. Review a week from, review next Thursday. Right? But you know what, the U.S. cases for today we can talk about in a few minutes. What I'd rather do at first is just sort of go through the procedures in the statute, explain the difference between delinquency, youthful offender cases, and also sort of go into a bit of history, because Massachusetts until 1996 maintained, used the old transfer laws, which were repealed when the youthful offender statute was enacted. Many states still do a transfer type of proceeding. One of the cases that, U.S. cases that you had to read about for today, the Kinzer U.S. case, sort of established, the rule that, before a child can actually be treated like an adult, the child court below has to have substantial, reasons in order to do so and so forth. So let me just begin first with asking you from the statute, as we did with chins, what's the definition of delinquency? And how is that different from the definition of chins? You don't have to know it verbatim, but very key.
It's a child between 7 and 17 who violates any city ordinance or town bylaw or commits any offense against a law of the Commonwealth.
Yeah. Basically a criminal violation. Later on, one of the mass cases that you have to read for Thursday, the Commonwealth v. Weston case was the Lowell juvenile curfew case that at the time, treated children as delinquent for violating an ordinance. So, sometimes we forget about that piece of it. So it's a violation of, criminal statute as well as a town bylaw or whatever. Notice the age, 7 to 17. And I think I mentioned, historically when we started talking at the beginning of this class, how before there were juvenile courts, basically 7 used to be sort of the age of reason, that before that, under that a child, didn't have the, mens rea to commit an offense. But at the time, again, when there were no juvenile courts, if a child committed an offense from 7 and up, that child had the same punishment as an adult would have. So some of these, and then you're going to see the 14 to 17 range. Some of these ages have some sort of semblance of reason for the categorical jurisdiction in terms of age. So it's 7 to 17 for delinquency, and that's in section 52 of the statute. The delinquent / YO part of the statute starts at section 52 with some of the definitions. And actually it's in 53. Remember when we initially looked at 119 and we started the camp protection cases, 119 section 1 was the preamble, the purpose of the statute. Well, 53, section 53 is the purpose clause of the delinquency statute. And it's interesting because you're going to see, as we've seen even in the chins, that there are, that the proceedings appear sometimes to be criminal, like adults, and then again, sometimes to be different because it's cases dealing with children. And actually 652, has a quote that's, used over and over again. It says that and I'm not going to read the whole thing, but it says that children are to be treated, quote, not as criminals, but as children in need of aid, encouragement, and guidance. And it's interesting because it also said this proceedings against children under said section shall not be deemed criminal proceedings. So section 53 says they're not criminal. There's another section of the statute, I forget where it is, but it says that proceedings under the statute shall be commenced and followed as criminal proceedings in the Superior Court, and the rules of criminal procedure apply. I don't remember what section that is, but that's 53, the purpose clause of the delinquency statute. So, and you all know what the standard of proof is, beyond a reasonable doubt. Standard of proof, beyond reasonable doubt. What other, thinking back to Galt, notice that I had Galt as the first case in this section. What other procedural and other due process rights does a child charged with delinquency in Massachusetts have? Notice, and so, I'm sorry, you said notice? Notice to who? Yeah, so there's notice to the child like an adult, but because it's a case dealing with children, the notice goes to the child and parents. And typically the judge does look for, you know, are the parents here, parents in court, or either of the parents, you know, why aren't they here? You know, let me continue the case, let me send out a summons to see why they're not here. In fact, the summons does go to the children and the parents. So, as Karen defined, child between 7 and 17 who allegedly has violated a town ordinance or a criminal law, okay? How is it different from an adult who's, you know, say an adult charged with assault and battery as opposed to a child who allegedly commits assault and battery? You're actually not charged with assault and battery directly. You're charged with delinquency by reason of having committed assault and battery or whatever the charges are. So it's a delinquency complaint that would issue, and again, I'm strictly just talking about delinquency right now. What are the procedural, what are the possible dispositions if the Commonwealth is able to prove its case beyond a reasonable doubt for a kid that's charged with delinquency? And the same thing goes if the case doesn't go to trial, but there's going to be, you know, plea and admission to sufficient facts. Amy?
The court can continue the case without a finding, with the consent of the child and at least one parent.
So they can be what we call cooperative.
Yeah.
What else?
Be placed on probation
Yeah.
until the age of 18/19.
Yeah.
Or, and it may require that they work or participate in activities of a type for a period of time.
Yeah. Some kind of restitution type of thing, or community service. What else is a possible disposition?
Probation officer.
Well, we already said that.
Commit to.
Oh, go ahead. Go ahead.
DYS.
Okay. So co-op probation, the case can also be placed on file.
What does it mean when it's on file? Does it?
Nothing.
It just
I mean,
it's not open
I can
and closed?
adjudicate you delinquent, you know, and then I get the input from the report from the probation officer. Maybe it's maybe you've been in trouble before, or it's an assault and battery, you know, some kind of serious, but not serious enough for commitment. So I'm going to adjudicate you delinquent, but I'm not going to do anything basically with the case. So it's different from a co-op in the sense that a co-op is no finding either way. I could adjudicate you delinquent, but not commit you.
So then,
the other thing that's really important, and this goes to the federal law. Remember when we looked at what DCF's obligations were in the context of a care and protection case? The DCF always had to be proving to the court, except in exceptional circumstances, that it had made reasonable efforts before a child could be taken. That actually applies in the delinquency cases as well. So if a child that's committed, and it's crazy when you think of it, but a child that's committed to an agency, in this case the agency is the Department of Youth Services, other than DCF, there still has to be this reasonable effort sort of certification, because again, it's still a child who's being removed from the home. When you think of the purpose of the juvenile court to begin with, called rehabilitation. Let's try and help these children and this family, so that before the child is actually removed and committed to DYS, the court has to be satisfied. This is the worst case scenario. This is sort of us, throwing up our hands that it couldn't be done, the rehabilitation, within the services that the court has, within the services that, are available to this family. So keep that in mind, that reasonable efforts. I don't know that much about it in terms of DYS, but it's there in the statute. Certification has to be made, or else you don't get the funding. So it becomes, a fiscal issue as well. Now, I mentioned before about the rules of criminal procedure applying. What does that mean in the context of representing a child? Go ahead.
it would be when jeopardy attaches, for instance, and they'd have to have a due process right to counsel, because if it's a criminal,
We forgot to put right to counsel on the board too. Go ahead.
because if it's a criminal complaint, you do have a right to notice to counsel, and jeopardy attaches in juvenile court at that time, and it cannot be then dismissed and transferred to another court. Oh, it can be dismissed, but it can't be adjudicated in juvenile court and then transferred to superior court again. I think I'm a little confused.
Yeah, keep the.
I'm mixing one case up with several I read did, and there's like conflict on the two.
Let's talk about transfer a little bit later, but that's not really what I meant. In that you're talking about certain rights that juvenile has, but in terms of rules of criminal procedure, typically what you see defense attorneys, what types of motions, for example, do defense attorneys file?
I think if he's under 14, they can waive his Fifth Amendment rights, like be tried as an adult.
Again, hold that thought. Think of rules. What are the rules of criminal procedure? Somebody give me a rule that they know from pro, maybe? I don't know.
The right to confront.
No, that's a constitutional right. What are the rules? These are court rules, right? The rules of civil procedure,
Suppression.
Joe.
They're all the things that you can do as an attorney to get your client, get dismissed or get evidence suppressed or.
Okay, so motions to dismiss, motions to
Discuss.
discuss.
Discovery.
Discovery.
Summary
No,
judgment?
summary judgment would apply if it for the civil cases.
Right to jury.
Suppose that an issue comes up, regarding competence to stand trial. So all of those adult rules of criminal procedure, apply to these children from the moment the delinquency complaint issues, right through disposition. We'll talk in more detail on Thursday about the differences. For example, the interested adult rule in terms of this, the child understands before he or she makes a confession, things like that. So rules of adult criminal procedure are again, due process rights as well, the notice right to counsel. What about right to jury trial? What did the U.S. Supreme Court hold in the guy with the Pennsylvania, one of the cases that having the reading for today? Cindy's shaking her head saying, I don't know.
I don't know.
Mark, what did the U.S. Supreme Court hold in the guy?
It said that due process in juvenile proceedings does not require a trial by jury. These are not criminal proceedings.
Right, right. Elaborate that a little bit more. Actually, does the great, you know, if you were trying to make an argument that juvenile, you know, that proceedings regarding children should be different from adults, the opinion, and then I'm looking at the year, you know, 1971. You know, that was the time when you had Galt. So, for example, on one end you had Galt. It says that, you know, stands for the proposition that children, when they are faced with proceedings like this, because they have a loss of liberty, have all of these due process rights like notice and right to counsel and confrontation, cross-examination, etc. But then the Supreme Court comes back with MacGyver v. Pennsylvania, basically, but just wait. We're not going to go all the way with these rights because there are differences. And so we're not going to afford juveniles the right to a jury trial because, Mark, you started to say?
I was thinking, now I just got back into this. So long as the other aspects of the due process is adequately served, look at it instead of here in the juvenile context, these interests may be adequately protected by allowing the accused individual to bring the community's attention to bear upon the trials. In Pennsylvania, there was no statutory bar to public juvenile trials. I think now they're in Massachusetts, they're not public.
So, what did you just say?
I said in Massachusetts they are closed, but in Pennsylvania
What's
this
they?
time the juvenile trials were open.
Yeah, and I forget, that's one of the sections, the closed public. So what about jury trials in Massachusetts? So we have the Supreme Court saying it's not a constitutional right, basically, the juveniles.
But Mass always affords more rights.
But Mass does what?
Always affords more rights.
More rights. And so where is the authority that Massachusetts affords juveniles jury trials, Leslie? Does Massachusetts afford juveniles jury trials?
I don't know for a fact.
Yes,
but
you
I
do,
bet
because
they
you've
do.
been in the
But
juvenile
I know
court.
they do.
Wait, who was in the juvenile court the week of jury trial? Somebody was
Oh, yeah.
here.
I was.
All right.
There was no jury. We didn't see a jury at all.
Somebody
Not
was
one.
there the week of jury trial. Maybe
No.
it wasn't online. Somebody out there.
Yeah.
Yes, we do. We do afford jury trials. Where is it, Geneva?
Section 56?
55A, I think. Is it?
55A, yeah.
56, Geneva, is something else, and that's the dispositional stuff. Yeah, so we do have jury trial. Yeah, in one instance, very good example too, whenever you're thinking, whether you're answering a question, it doesn't even have to be in here. If you were trying to make an argument, you know, a general argument in another course or for a court case that you have, or that, and you are outlining all the instances where Massachusetts offers more rights than the feds, this is obviously one of them. Juveniles have the right to jury trials. So remember when we did Galt at the very beginning, and we did that little mini exercise where after the Galt case was decided and Jerry Galt first appeared in court, right? So, you know, he enters the plea of not delinquent because he wants to go to trial, right? And the next thing he has to do is make that election. Do I want a jury trial, or am I going to waive jury trial? So in Massachusetts, if you're going to waive, again, because you're a child, you can't just waive it yourself. So either you're going to have counsel waive it for you, or you might have waived counsel. And if you waive counsel, you've got to have your parent involved in waiving counsel, right? So, you know, every piece of paper, every decision that the juvenile makes that's a legal decision is, along with counsel or with parent. So you've got the right to jury trial. Now, and I'll come back to delinquency, but I want to now get into the youthful offenders and what you guys mentioned transfer hearings before. In 1996, Massachusetts actually repealed its old transfer law. That doesn't mean that the older decisions don't still stand for some general, proposition. So they're not all the older decisions are not completely abolished. For example, one of the cases that you have to read for Thursday's Commonwealth v. Matthews, it was a 1990 case, and it was a really heinous crime where Rod Matthews had invited a friend over after school, and it was around February or so, and had taken him.
In Canton?
No, this is way earlier than that. Maybe it was Canton. He had bludgeoned him to death with a baseball bat, and actually then took friends to see the body and whatnot. Under the old law, well, I'm trying to remember if he was transferred, whatever, but in terms of what the court still looks at, in terms of factors for rehabilitation and so forth, the case still stands for those early propositions, even though it was procedurally, under the old transfer law. Let me just tell you quickly what used to happen. So you had, delinquency complaints, started in the juvenile court. And they were, cases where a kid was older, obviously, than 7. Usually it was over 14, or the 14 to 17 age bracket. And the child had been charged with, really serious crimes such as, rape, manslaughter, murder, etc. And the Commonwealth sought to have that child actually transferred out physically, geographically, whatever you want to call it, out of the juvenile court into the superior court. And in order to do that, the juvenile court would hold in juvenile court a transfer proceeding that actually consisted of, they called it a Part A and a Part B, 2 parts. One was the probable cause hearings that you normally hear about, that are usually held in order to bind an adult over to superior court, and very low threshold. Is there probable cause that a crime was committed, and is it probable that this defendant committed this crime? So that was the Part A. The Part B of it was really the transfer piece of it. And notice, and this was all before trial stuff. Whereas when we get to the YO, it all happens after trial. So with the Part B then, the Commonwealth and the juvenile present whatever evidence that they wanted to convince the judge that the juvenile should remain within the juvenile system if you're the defense, because that juvenile could be rehabilitated, or if you were the Commonwealth, that the juvenile was dangerous, either what the juvenile did was really serious, really dangerous. He was dangerous and not amenable to rehabilitation. Anything and everything could be admitted, school, people testifying, whatever. One of the, and the statute actually went, and I'm not going to go into it in detail because it's been abolished, but just so you know the history, the statute actually went through lots of changes, making it, and the changes, it gradually made it easier and easier for the Commonwealth to get the child out of the juvenile system and into the Superior Court adult system. One of the cases that spawned one of the changes was, and I can remember some of the defendants' name, Damien Bino, I don't remember one. There were 3 or 4 defendants, and Taryn Harris, Willie Dunn, Damien Bino, and I think it was Damien who was the shooter in the case. A child was sitting on front steps and, drive-by, blah, 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 was shot. So Willie Harris and Tarandanta's vesting is done. They were actually transferred out in Superior Court, to Superior Court, because they didn't have the, they didn't have their attorneys, they didn't have a lot of money, basically, in terms of, getting the evidence and getting the people to testify for them and so forth. Damien Bynum, who was the shooter, was actually not transferred out and dealt with within the juvenile court. So, there were inconsistencies in the system. If you could convince the court with what evidence you have that you were amenable to rehabilitation. And there were a list of factors, and we'll look at them because a lot of the factors are still now in the new youthful offender statute. And actually what then spawned the youthful offender statute, and I know you all know this case, Eddie O'Brien, who was about 14 or 15, big, huge kid, still looked like a kid, but bludgeoned to death 93 times. His neighbor's, his friend's mother. Yeah, and that was under the old system. It was shortly after that that the statute was changed. And this is the way it was changed. Youthful offender cases are still held in the juvenile court. Okay, so it's all, and we'll get to murder, everything. If you're up to 17 years old, your case is going to be heard in the juvenile court. But if you're 14 to 17, the Commonwealth may, and the statute says may, and I'm not going to go through the instances there. For example, if you've been DYS 100,000 times before, the important one is if you committed an offense that involves the threat or infliction of serious bodily harm. But the thing is, the discretion is placed with the district attorney. The district attorney may, again, according to the statute, seek a youthful offender indictment. And if that's the case, it's still in juvenile court. The case proceeds through the juvenile court. Same rules that we talked about before: notice counsel, rules of criminal procedure, etc. All right, and it's trial first. And this is what's different about the old system. Sentencing hearing second. So the old transfer law was the transfer hearing was first to determine if the child was amenable to rehabilitation. Nothing about the offense, other than the probable cause piece of it, but everything about the child the judge got to hear. And then you had trial. But now, if it's going to be a youthful offender case, the trial is held first, and then the sentencing hearing is held. And I want to just point out the section of the statute. By the way, youthful offender is defined in the beginning, just in the same section as delinquency, pretty much in more detail of what I just said. Oh, by the way, section 54 that says complaints and indictments shall be brought under the Mass Rules of Criminal Procedure, shall be brought in accordance with the usual course and manner of criminal proceedings. So it's section 54 that, remember before we said 53 said not criminal? It's the very next section that tells us that they're not criminal cases, but we're going to run them like criminal cases, basically.
Just like they say, you're not gonna have a record, but you're gonna have a record.
Exactly. So what I was looking for, if you look at, I think it's 58 or so, if I can find it. Yes, there it is. So 58 gives you, when we discussed earlier, the delinquency options. The co-op with probation is the first paragraph, pretty much. Second paragraph talks about filing it, placing it with a probation officer, or the commitment to DYS. Then sections A, B, or C talk about the 3 dispositional alternatives that the judge has after the sentencing hearing. So it's A, B, C. A is the sentence provided by law, unless I'm saying it backwards, but I think it is the sentence provided. And that's the adult one. B is your combination sentence, C is your DYS, your juvenile sentence. So the juvenile court judge, after hearing this trial, can commit to, all sentence provided by law means whatever we're gonna give an adult, we can give this juvenile. So that's the worst case scenario. The combination is the next one down, which is DYS, and then Department of Corrections after that. And then DYS is the same that you would have gotten if you had a delinquency trial. Now what's important, well, it's all important, but the sentencing hearing, and I'll just read you some of the factors because it's, again, the factors contained in the sentencing hearing today are pretty much what we used to use in the old transfer cases. The nature, circumstances, and seriousness of the offense. For example, when you do read Matthew's case, he was never in trouble before, but just the offense was so bad, so hideous, that's what the court concentrated on. The victim impact statement, the report by the probation officer, the juvenile's record, past treatment, the nature of services, the age of maturity, supposedly maybe he's 16 and a half, for example. So the court looks at this, and the standard, which I can't find it somewhere in the statute, whereas the old transfer hearing used those factors, in the old transfer hearing, the judge is thinking about rehabilitation. However, in the sentencing hearing, the judge is not thinking that much about rehabilitation. The judge is thinking about public safety, somewhere in that section. The safety of the public is the paramount concern in the sentencing of a youthful offender. Now, suppose that a juvenile has killed another child, and the Commonwealth is thinking about seeking actually a murder indictment against that child. The child is from 14 and up. Juvenile court does not have jurisdiction. So that's the one case where the actual trial, first degree for murder cases, will be held in the Superior Court. So what does that mean in terms of the child and the punishment?
That would be, but also his punishment would not be, say, the capital, it would be life in prison. This is automatic sentence of ages 14, 15,
Yeah, so you have the combination, and I was looking for the section, I think it's 72B, or it's one of the 72s. Of 119, it's one of the section 72s, I think it's 72B or 72B.
72B, yeah.
Okay, and what's our life 265-2, something like that? That tells us that the punishment for first degree murder is life, mandatory, no parole, etc. So it's really the combination of 119.72 and 265 that makes it, again, mandatory. The Commonwealth has proven its case beyond a reasonable doubt in first degree murder. The child's between 14 and 17, that child's going to be doing life. Second degree, obviously, would be life with parole.
But if less than that, it would go to delinquency.
I'm sorry, I didn't hear
If
you.
you're less than 14, it would go to delinquency.
Okay, yeah. So the most hideous murder that you can think of,
Yep.
if you're less than 14, I'm sorry, if you're less than 14, you're in the delinquency. You're in the delinquency jurisdiction of the court.
Which means it's not a mandatory life. They could do it, couldn't
It is a mandatory life.
they? Even if you're in delinquency, less than 14.
I'm sorry, I didn't know what you were saying. 14 to 7, this is all 14 to 17.
So what if you're
Principal offender, 14 to 17. Murder, 14 and up. Okay? Below 14 is delinquency. Think about the reasons if you're below 14.
But they could do a combination if they're below 14.
Nope. What are the ages? Again, 7 to 17 delinquency, 14 and up. Delinquency, worst case scenario for delinquency is what? DYS until 18 and then 21, right?
Right.
That's it. You're done, you're out.
Right.
If you're a day under 14. Ed?
So, if a 16-year-old commits first degree murder,
Yep.
he's going to be held in,
Okay, you're thinking now of where physically he goes, and that's a different story, right? Because you're under, okay, you're not gonna go to MCI, I forget where you go, but you're in what's called a youthful offender unit. You're not mixed with the adult population.
and you stay there until you're 21?
Yes. Yeah.
But if you
so-
kill somebody when you're 18, you go directly to jail?
No, again, you're not mixed. If you're underage, you're still gonna be, you might be doing life. You might be doing life from 14 and up. Where is Ogden? What's his name, Ogden? You know who I'm thinking of. Do I have his name on?
The one who just.
Sudbury, the kid with Asperger's?
Yeah, with Asperger's, yeah.
Where's he physically housed right now? I don't know how old he is right now. Is he of age yet? So he would have, I don't know where he went first, but wherever he went, because he's underage, they have separate for them, the youthful offender unit of whatever jail he went to.
But he's saying if you're
But
18, you're an adult.
What I'm saying is if you did this at 16,
Yes.
you stay in the Department of Youth Services until the age of 21, then you get moved to an adult
If you-
jail.
Wait, if you did what at 16?
First degree murder.
Oh, okay, so I don't know if you're talking about just
No,
a youthful offender.
First degree murder, so
Yeah,
I'm going to be held from 21 in youth services, by the Department of Youth Services, correct?
No,
No.
that's not what I'm saying.
Okay.
You're tried as an adult, you get an adult punishment. Because you're underage, you're not gonna be mixed with the adults in the jail,
Okay.
okay? It's still gonna be Department of Corrections, okay?
That makes sense.
So wherever you go, MCI, Cedar Junction, is it Cedar Junction? Does anybody know?
That's Walton.
Is it?
Yeah.
Yeah. Is that where Ogden is now? I'll find out.
I think it said somewhere you couldn't be sent to Cedar Junction.
Say that?
I'm pretty sure it says you can't be sent to
Has
Cedar
he been
Junction.
sentenced already? If he has not been sentenced.
Oh, he's doing life. Oh, yeah.
Alright,
Oh, yeah.
he's been
Yeah.
sentenced, he can go
Yeah.
there. If he hasn't been, he can only go there,
That
he's
makes
done the
sense.
state time.
Wait, shh, one at a time. At 18, general population, is that what the youthful offender? Don't ask me about the ages, because sometimes I say 18, sometimes I say 21, and I could be wrong on, there are instances where it's 18 and other instances such where it's 21, so you gotta look it up. Joe?
One of the things that Judge Cornetto pointed out to us is the statute specifically says 7 to 17. If you're 17 in 2 days,
Absolutely. You're an
not-
adult.
you're
You're
an
in the
adult.
district court,
It's not-
district superior.
It's
Yep.
just till you turn 17, so it's really
Absolutely.
16-year-olds.
Absolutely, and remember how Mike Kelly was saying that there might be, there's rumblings about not only changing the jurisdiction in terms of age, but now the life sentence. You guys know that 2 Supreme Court cases were just argued, and the U.S. Supreme Court will be deciding in the next, I don't know how many months, whether life sentences in general for juveniles for homicide crimes. Because the US Supreme Court already decided, and it was one of the cases you had to read for today, Graham v. Florida makes life sentences for juveniles in what instances unconstitutional. Graham v. Florida was just set about a couple of years ago, I think it was 2010, right? Florida, what did the kid do? Not much.
Probation.
There were felony crimes, I mean, there were burglaries and.
Exactly.
He had three.
Yes.
But that was enough under the statute to give him life.
And there was an issue about probation and violation of probation and in and out,
So all
and the
not-
child was doing life. So the question, you know, when that case came up before the US Supreme Court, there were rumblings about, because of the earlier case of Roper v. Simmons that held that the death penalty was unconstitutional. And before that, the Atkins case, in terms of the, mentally challenged, the death penalty is also unconstitutional. There were rumblings that the Supreme Court might have expanded in terms of Graham, but it became a very narrow holding. And so consequently, the two cases that Alabama, and I forgot the name of the other case. It's another state. So there's one out of Alabama, Miller v. Alabama, and I don't remember what the other is. So there are two companion cases that the Supreme Court heard just 2-3 weeks ago at the most, that were actual homicide cases where juveniles in fact, one of them I think was only 14. They were very young. They weren't like 16 going on 17. I think both were very young. So that will be decided soon. Speaking of Roper v. Simmons, because that sort of was the case in which the Supreme Court finally had something, well, even before with Atkins, but particularly with Roper because Chris Simmons was obviously a child when he committed this pretty heinous crime. What did Simmons do? What was his crime? Yeah, how did he do it, Jamie? Because it was...
That's when he snuck into his family's home and murdered this older woman while her husband was away on business.
He didn't murder her in the home. What did he do to her?
He kidnapped her and he tied her hands and feet with electrical wire, wrapped her whole face in duct tape and threw her from a bridge.
From a bridge. Exactly. Was on death row pretty much, so appeal after appeal after appeal. Now at the same time, over the years, you had all this research that had begun, the MacArthur Foundation, Harvard, New York, research all over the country into the, research not only on the brain imaging, but so neurological, physiological, sociological, all of these factors coming into play in terms of juveniles' culpability. What's culpability mean?
Maybe if you're able to form the intent, like you can take responsibility for your actions.
Yeah, elaborate on that in terms of the difference between a juvenile and an adult.
That your brain's not fully developed, your maturity level's not fully developed, so you don't know the repercussions of your actions. So because of that, you shouldn't be held accountable in the same way, similar with like insanity. You might have committed murder, but you weren't able to understand.
And the popular term that you heard and still hear over and over, not guilty by reason of adolescence. So yes, culpability, in terms of understanding what you have done. And if you can't understand, and it kind of, again, goes back to the differences, the old differences that were talked about originally when the juvenile court started. So are we sort of, coming back to that? The treatment of children differently from adults? Or, and does that mean that the court will be, become more informal again and less process and whatnot? Or can we, if you're gonna be a defense attorney, for example, can we use sort of those teachings to make the arguments all along? Say you have a motion to suppress and you base, again, your legal arguments on the culpability of the juvenile at the time of the crime. Not to be confused with the competence issue, right? So competence is what? As compared to culpability. Karen?
In order to be competent, you have to be able to assist your attorney in your defense. You have to be able to understand and assist.
Okay, all right. So is that the same standard for adults? Kate?
Yeah.
Yeah?
Same as
Mm-hmm.
juvenile and adult.
Yeah, remember we talked about the rules of criminal procedure, I think it's rule 14B or somewhere in the 14, that it could be a defense in terms of, wait a minute, I have it the wrong way. The criminal responsibility is the 14. I forget where competence is, somewhere else. But competence goes to you today, right? You might have been crazy back then when you did it. But today, you understand what's going on, you can assist, as Karen said, in your legal defense. Whereas, again, using the culpability argument, and the Supreme Court, besides getting back to Roper v. Simmons, what was the I just mentioned the scientific stuff, but what was the constitutional argument for abolishing the death penalty for juveniles? What was the constitutional argument? Joe?
It was the 8th Amendment, cruel and unusual punishment for a crime. I think that exceeded the bounds of what would be fair punishment.
Okay.
And the 14th Amendment.
So let me ask you this, in terms of what's before the Supreme Court now, life sentence cases where the juveniles had committed pretty heinous crimes similar to what Chris Simmons had done, but he was, on death row. They're alive. Waiting to die in prison. So can the same argument be made for life sentences? So the same sort of thing, the punishment doesn't fit the crime, the 8th Amendment, et cetera, the standards of decency, the international consensus. Can you make those same arguments for juveniles doing life that, again, that have committed pretty horrible crimes? What's the argument against it? Sandy?
You can make the argument, I think.
Make it.
You can argue anything.
See, the problem is we're one of the states that have the mandatory life for first-degree murder. And because that we do, and because of the way our juvenile statute reads, that, and it doesn't happen that often, so one of the arguments against it is easy. It's the word, oh yeah, we still care about juveniles, and we still treat them differently, we still have, they're not criminal proceedings, children in need of aid, encouragement, and guidance, but there are times when that's all failed for this person. This person can't be saved, this person can't be rehabilitated. Look what the person has done. And not only in terms of rehabilitation, but if you think of just the sort of the philosophy behind criminal justice in general, that some, they call sociopaths, for example, can't be saved, can't be rehabilitated, the criminal mind, etc. The worst of the worst. So this person doesn't belong in the system, this person doesn't belong out in public, the public safety is paramount, et cetera, et cetera. But then you balance that again against what we know today about children's brains. But can you totally be using that argument is what I'm asking. You know, it's hard, huh?
Yeah, I was gonna say, it's really hard because you do have some children that are far more mature than other children, and those ones that you honestly, if you talk to them, you know they know what they were doing, and they didn't care, or, you know, heinous things.
And remember, that was one of the items in the sentencing factors too, in the YO cases, the age and maturity of the child. You know,
I think now too with the registry of sexual offenders,
Oh, God, that's
it's
one
also
other
a
issue.
huge thing. Because I had a case where the kid was really probably intellectually and maturity-wise about 6, but he happened to be 16 when he touched his cousin inappropriately.
Mhm.
And so he, you know, ended up being found guilty of being a sex offender and was on the registry for the rest of his life.
After trial, it was a plea.
It was a
Do you know?
plea, yeah.
They
Ended up being
couldn't
a plea.
knock it down to like
I don't remember
regular A and
exactly.
B
what
or-
yeah, no, because he did go for treatment. He was committed to
Mhm.
DYSD when he was in
Mhm.
treatment until he was
Mhm.
19, and then he was released. But he had to register.
Yeah.
And he didn't understand. He didn't understand the registry. I'm sure he's not registered. He moved to a different state, so.
Oh.
I don't know,
Oh.
but I'm guessing, you know, I mean, the consequences of that are huge.
Yeah, it's been determined by, you know, the Commonwealth, when those statutes first were enacted. I remember there was a big hubbub about, do they apply to kids? You know, cases went up to the SJC, and yes, they do apply to children. You know, the adult bail statute applies to children. You know, so many criminal-like procedures apply. Again, if you're a child from 7 and up, charged with any kind of crime, the case is basically criminal. It really is. Even though a delinquent can only be, you know, placed ultimately with DYS and not with an adult facility, the case is basically, in all other respects, you know, and especially in Massachusetts, a criminal case. What was the holding in Winship? And we've already got that right up here on the board. So again, these were all the cases from the 70s, the constitutional rights era for children. Here, Gall, MacGyver went the other way, but you know, Winship, Reed v. Jones was double jeopardy. Kent v. US was the transfer. You can't just transfer arbitrarily. You got to transfer with you know, a set of reasons, with standards. What was Winship? Easy. You could say it in one word. Amy's saying, yeah, I know.
Reasonable doubt.
Yeah, standard beyond a reasonable doubt. It seems so simple when we think about it today, but so that meant before that time, there were no standards like that in cases where children were committed. There were landmark cases at the time, again, that set the standard by which these proceedings should be held, because the proceedings were essentially, you know, in spite of what the statute says, essentially criminal cases.
Is this, do you think, because historically back then the laws were written for adult punishment, and children are basically punished by the parents, and they kind of, the government sort of delineated that distinction?
Are you going all the way back to sort of the parents' patriae?
Perhaps back then, even back to the 40s, 30s, I think the government, the state looked at children as being under the rule of their parents.
Oh, absolutely.
And I think we've now become the parents as a state.
Mm-hmm. So no questions about the differences in the proceedings? Joe?
I just wanted to say that I read a book recently that said that even though the beyond the reasonable doubt standard is there, that lots of judges actually still use something less than that because they're
Crazy,
trying,
huh?
to help the child in a way. It doesn't matter if we can sometimes absolutely prove that somebody did something. If the kid needs help, he needs help. And if you go back to what the purpose clause that you started with,
Right.
53, you say that maybe beyond reasonable doubt doesn't make sense in all cases. You're not necessarily helping the child.
Yeah, again, going back to the parents patria, the informality, the differences in the proceedings, if we're going to dismiss the case, that means the child walks and doesn't get services. But if you're placed on the attorney end of it, however, then you're faced with the whole role of counsel issues, and so that isn't something that an attorney can make the decision about. Right? So you do what your child wants or wishes. If the child doesn't understand, it's a substitute judgment rather than I want what is best for the child. In spite of the fact that the child might walk and be back on the streets again, committing the next offense. But that's not your job. Sad, in many ways, but however, if you can build the relationship with your child client, because you're an advocate, but you're also an advisor as well. So in advising the child, so you've got a kid that's is getting into trouble for reasons. If somehow maybe a plea. Even though that child has the absolute right to trial, doesn't have to do anything, Commonwealth has proved beyond a reasonable doubt, maybe the plea is what would help him or her. And maybe it's just going to be a quaff or, but something that sort of keeps him or her in the system. Is there a way that you can sort of advise the child, but that it does become the child's ultimate choice? But you have to have that, the relationship to do that. Yeah.
Because then don't you run the issue of ineffective assistance of counsel?
Right. So, when the child shows up at court to do the plea, the judge is also going to go through, the soliloquy here, the colloquy. I said soliloquy. The colloquy. I'm sorry. The colloquy. And the judge has to be, really, really satisfied. And you'll see judges say, did you talk to your attorney about this? Oh yeah, and he told me to plea. Oh God, even though I didn't do it. So you have to be careful that it doesn't just become, you sort of saying you got to do this. So that takes a lot of time and effort because it's not just the adult client, it's the child client. So with all of these other things, besides the law that you also have to know, biology and sociology and cultural differences and all of this other stuff. That's why we have so many seminars all the time. And the law changes so much in this area, I'm telling you. So much. Every year it's like that. This case just came up. This issue just came up. This is what's going on. And really, we've skimmed the top of so many of the issues in this class. So on Thursday, we'll do all of these mass cases. We'll get into what for example, the interested adult standard and some of the standards peculiar to Massachusetts. Next Tuesday, again, the differences in the federal student search standard versus the Massachusetts standard, and then Thursday we'll do, even though my syllabus says role of the lawyer, we've been talking about growth, your role all along. I'd rather do review if that's okay with you guys. And I have a little sheet that I give out at the review and go over all of these terms, standards, whatever you. Okay. Yes.
When delinquency cases happen in juvenile court, youthful offenders cases, they
Juvenile.
say, they juvenile court, they say,
Juvenile court.
they call it juvenile court of, a juvenile of the district court.
No.
It mentions of the district court a couple of times.
Oh, I'm sorry, no, you know what that is, Joe? When I started practicing in this area, we actually went to the district court. There were no separate juvenile courts, and it was a room, any of the courtrooms designated as the juvenile session. And so you couldn't, so the judge that went into that courtroom couldn't hear, say, even if an adult got paid in that, he'd have to go into another courtroom. So that you still see the statute saying the juvenile blah, 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 or the juvenile session in the district court. But you just reminded me about something. We have on the board the delinquency cases closed to the public. The YO cases are not. And frankly, I think I was enrolled maybe once when a YO case came in, but it was still closed because who knows that to go in, unless you're really directly involved or know about this youthful offender case, you're not going to walk into the juvenile court to see, one of the 2% or whatever it is of youthful offender cases as opposed to all of the other juvenile cases, because you can't get into that courtroom otherwise, you know what I'm saying? So it isn't like, they advertise that there's going to be a youthful offender case and the public can come. But, technically, according to the statute, they're not closed session cases, the youthful offender cases. But in a sense, they really are, You're saying about juries? No, that isn't the difference. The difference is the youthful offender case is more supposedly, more like an adult type of case. It's the children 14 to 17 that have committed they're the serious cases. They're more like adult cases. So the reason for the closed hearings in the delinquency cases is because these are children, and the public shouldn't be, know about not only delinquency, but the camp protection cases, the chintz cases, etc. Those are all closed to the public. That's why when the parties check in with probation, they get numbers, and so in the hallway, you're not going to hear, camp protection called this, or Commonwealth called this. You're going to hear, case number 3, case number 4, case number 60, etc. Right? Because they're closed to the public, so the case names are only talked about, within that closed session. All right, we'll do the mass cases. Ended early. I thought it would take me longer to go through the differences because sometimes it can be tricky. But mass cases on Thursday.